Thanks very much, Isadora, and good to see everyone. Hopefully many of you have come to these sessions before, and if you're new, forgive me for all my foibles and eccentricities, but we will get to the more interesting speakers in a moment. So this is another speed dating session. I think it's the fourth that we've done, or fifth we've done over the last 18 months. One would hope with so much speed dating, perhaps I might have got a date, but that hasn't happened yet, but we'll work on that later. This session is entitled Data Privacy, Fines for Data Breaches in the Workplace. We're going to also talk about enforcement action more generally and trends we're seeing from regulators so that you get the most colour. We've got very interesting speakers today, as Isadora said, and we're going to try and run through as we always do so you can get as much colour as you can from various different jurisdictions to get the most benefit from the session. But as always, I'd quite like to just start with the basics and set the scene. I'm just going to talk about the types of enforcement action, Article 83, GDPR, and so on before we move on to some of the actual cases from the countries. But there's various types of enforcement action that can happen from regulators. And although we frame this as data privacy fines for data breaches, in the main, the type of enforcement action you'll probably most commonly encounter is, a letter from your local supervisory authority. We at Lewis Silkin deal with, hundreds of letters a year from the ICO, and we also help our colleagues around the world with their regulatory interactions. And that doesn't always result in a fine. It doesn't always result in a sanction or a mandatory action that you have to take. It can often just be, rather a tortuous and expensive and time-consuming process where you have to answer a regulator's questions, but it doesn't necessarily result that a letter or something like that can be the beginning of the process up towards a fine. So don't disregard those letters when you get them, and just don't remember that this seminar is only about fines and think they're the only important things. Even the small stuff is very important. And obviously the ladder of enforcement action then rises to an investigation from the ICO or the IDPC or the CNIL or the Garante in Italy or a regional regulator in Germany, all the way then up to a notice. And that notice doesn't necessarily have to set out a fine. It can simply set out the company was cooperative. However, we feel they should do 1, 2, and 3 over the next 6 months, 9 months, 3 minutes occasionally. So that's kind of the ladder of what can happen under GDPR through the regulators. And it is broadly the same in each jurisdiction, including the UK, because it all comes from GDPR. And then the main thing we're going to talk about today, fines, is all governed by Article 83 GDPR, UK GDPR. It's certainly worth you having a look yourselves. It's actually trickily easy read. It makes you think that the concept of a fine is a very clear thing that is very easy to understand. But the key thing I want to read out to you now is H3.1. Each supervisory authority shall ensure that the imposition of administrative fines pursuant to this article in respect of infringements of GDPR shall be effective, proportionate, and dissuasive. So that is the absolute key thing. They want fines to be effective, proportionate, and dissuasive. So you're going to see some of the fines we're going to talk about today are quite small, and you wonder whether they are dissuasive, but you're also going to see some of the fines that we see today and talk about today are actually quite large, and you wonder whether they're perhaps too dissuasive and perhaps they might be disproportionate. So it is quite a mixed bag. And if you were to read 83 yourself, which I recommend that you do, it sets out 10 ways that a regulator will look at a fine and how much it should be, from the nature and the gravity and the duration of an offence to the intentional and negligent behaviour, weighed against cooperation from the data controller or the data processor. So it's all the standard common sense stuff that you would expect. And again, there is domestic nuance in each country. In fact, Jessica could just give a thumbs up if people can see it, but in Germany, there's quite a large paper from one of the regulators, or it's even from all the regulators, setting out how they will approach fines. And equally in the UK, we have the ICO's sort of guide to enforcement. So they have actually put colour and meat on the bones of Article 83. And that's similar in all jurisdictions, but underlying all jurisdictions is that Article 83 reasoning. And of course, effective, proportionate, and dissuasive underpins the whole thing. So, dealing with letters can take months and months and months. Dealing with an investigation and then the potential issues that come with a notice can take not just months but years. You'll see from when Linda talks about some of her Irish cases, which aren't necessarily related to the workplace but are very high profile, that some of these fines and investigations from the IDPC have been 2-3 years in the making. So they can be very long, arduous, time-consuming, management attention diverting practices. So I've nearly finished before, and we're going to move on to Jessica in a moment. But I did want to talk about what I'll call the sibling of Article 83, Article 82. It's not the focus of today's session, but Article 82, the right to compensation and liability for a data subject, Article 82.1 saying any person who has suffered material or non-material damage as a result of an infringement of GDPR can receive compensation from either the controller or the processor. You have to recognise that that is an absolutely crucial sibling of Article 83. If there has been a fine as a result of an infringement of GDPR, it is very common, certainly in the UK, less so I know across continental Europe at present, but it probably will get more commonplace over the next 2 to 3 years. It is very common then for individual claims, dare I say it, class actions to then follow as a result of a fine. So fines are very important, but they're not the end of the story. We do often see after fines and even enforcement notices, huge swathes of individual and class action claims. So that's the setting. I hate doing it, but it's the legislative setting, but I hope that was mildly interesting. But as you can imagine, in the workplace, there's obviously, as I always say, lots of data, some vanilla data, some is sensitive data, lots of different types of processing, some basic, we need to pay people, some quite intrusive, and we're going to lead on to Jessica's first case, which may or may not be intrusive, depending on your point of view. And so there is lots of space for the potential of complaints and therefore the issuing of fines. So that's my intro done. We're going to go on to a run through with Jessica from Germany, Linda from Ireland, Philip from Holland, Guillaume from France, and Marco from Italy. They're either going to take you through an interesting case or cases that have happened in their jurisdiction, or talk about trends that we're seeing. And I will, all the way through, interject with, no doubt, a load of nonsense. And as Isadora said, although Isadora, I must say I can't see any Q&A on my screen at present, but someone will contact me if there are any questions of interest, and we'll try and answer them, of course. So without further ado, I will move on to say welcome to Jessica Jacobi from Klimt in Germany.
Thank you, Alex. Thank you, Alex, for the intro and also for the background. Maybe just responding with one sentence, I think we are a bit further behind with the damages claims that you just mentioned. The amounts are starting to be awarded, but they are way lower than the fines which have been awarded in Germany lately. I will present two cases from Germany, one now and one towards the end of the session. I will start with a case which happened almost a year ago at H&M, the clothing chain. There had been extensive monitoring of employees and their personal circumstances at the store in Nuremberg, which is in Bavaria, and the Hamburg authority was in charge of this because the legal seat of H&M in Germany is Hamburg. They issued a fine of 35 million euros. So this is certainly a record amount. What is a really good learning from this case is how the company reacted. If the company is being fined, there are various aspects to be considered. And one of them is that they used a cooperative approach. They were transparent. Once this breach has become known to the wider circle of management, they have prepared a concept how to prevent this from happening in the future. They have awarded financial compensation to employees, and they have accepted the fine. That might also be an aspect of also public relations, which is of course important in being, if there's a breach being found by the authorities and it is being, and a large fine is being issued. So I think those are important learnings to take when something like this happens and the management finds out and has to deal with the case and the fine. So that is the HM case, and I'll move on to Philip, I guess, for the next case or for the situation in the Netherlands.
Yeah, and I'll just say, just before I move on to Philip's slide, I mean, 35 million is a very, very large fine for a workplace act of infringement of GDPR. And it does surprise me. I know H&M obviously did cooperate, but I dread to think what the fine might have been had they not cooperated. So I think that is a key point. But I think we in the UK were surprised by the level of that fine, bearing in mind the issues at hand that obviously everyone can see on the screen and take away, where the risk lies. But I mean, was there surprise across Germany at the size of that fine, or is that a particular quirk of Bavaria versus, say, Hesse or other regional regulators? Is Bavaria more aggressive in its fine profiles than other regional regulators in Germany?
Well, it was Hamburg, and Hamburg is known to be proactive, and they have been proactive even before the GDPR. In general, you could say that Northern Germany is a bit more strict, and Southern Bavaria is a bit more economy friendly. But nevertheless, it was intrusive monitoring, as you sometimes have in certain whatever small areas of a company where something develops and nobody really does a monthly or yearly monitoring or enough trainings for people. And so something develops which should not take place. And it was intrusive. And so, of course, it was a severe case. And of course, it was a record amount, especially since the amounts were at that time just growing. And and it is of course beyond the 20 million, so it was related to the turnover. I will get to that paper which you mentioned later with Notebooks Billiger, because they were actually complaining about the amount as opposed to HM. They did not complain about anything. They decided not to challenge it. But of course, there's a discussion about this paper, which you just mentioned, Alex, how to calculate a fine, because it refers to the turnover of the company as opposed to the profit. So even if you have a large turnover, you may not be able to afford the fine which you're being handed out.
Yes, and just to clarify for everyone on the call, obviously the fines can be 2% or 4% of worldwide turnover, up, or obviously with 20 million or 10 million, whichever is potentially higher. And there are often a lot of discussions. Which turnover are you looking about? What does worldwide mean? And in some cases, we've been involved with that. There have been huge discussions with regulators about what is the actual pot of gold that they could grab from. Well, Jessica, that's fascinating. We look forward to hearing from you later about the other case. I'm going to move on to Philip now for, I think, two slightly different cases in the Netherlands, but both very interesting. Thanks, Philip.
Yeah, in the Netherlands, the amount that Jessica just mentioned are nowhere to be found, especially if you look at the fines that are employment related. First of all, the first year after the GDPR came into force, the Dutch DPA used that first year to inform the public about the GDPR and making everybody aware of it. But then they said in their yearly report, end of 2019, there is going to be more focus on enforcement. So it sounded a bit like the gloves come off. But if you look at the figures, it's not quite the case. And by the way, there was already a data breach reporting obligation in the Netherlands 2 years before the GDPR came into force, but never was any fine imposed yet. The first lucky one was Uber in the Netherlands because of not timely reporting a data breach, but that was not employment related. And now we are slowly seeing that this year the number of fines is slowly climbing. But not the numbers. If you look at the amount, sorry, not the amounts. The amounts still are no way to be compared with the 35 million. Let me highlight two, actually the only two fines that have been imposed that are employment related. First of all, is actually quite similar to the situation of HM, but with a very different outcome, as you can see. It's a small Dutch maintenance company, and they were processing health data in the same way, more or less, perhaps. What they did was ask their employees to answer online questions like, what is the diagnosis if you are ill? What type of medical institute are you visiting? And questions around prognosis, things like that. In other words, serious breach of both the data minimization principle and unlawful processing of medical data. And if there's one thing that is that the Dutch DPA is very serious about, then it's the processing of medical data by employers. But looking at the fine, it's of course, like I said, it's a small company, and they linked the fine, the amount of the fine, to the size of the company, but there was no reference on their responsiveness or the level of cooperation or anything. They only said that based on their own guidelines, it would have been a little over 1 million euros, but in the end of the day, the fine was 15,000. So that was quite interesting to see that big difference. And the only reason they did it is because it's a very small company, but there was not linked to responsiveness or level of cooperation. The other one is perhaps even more interesting, not because of the amount of the fine, but because what happened afterwards. As you can see in the slide, it was unauthorized use of biometric data for entrance and time registration purposes, which is of course not allowed. But then, as you can see, no name of the company is mentioned, simply because we don't know. What happened was that right after the fine was imposed, this company went to court for what we call een kort geding. It's a short-term, urgent type of court case, and they asked the court to anonymize the decision of the DPA, and apparently they won. Because they said the full disclosure would cause serious damage to the company financially, regarding its market position, its reputation, etc. And if you look at the court case, the arguments that were brought in front of the DPA were only about, yes, it is important to inform the public and all those kinds of things, but there was never a link to why is it important to mention the name of the company that was being fined. So the company won, and we will never know what the name of the company is. And then finally, just one thing that happened, and that was filed today and just a minute ago. So I had in front of me a 200-page writ of summons, which I have not yet read, but it is interesting to see that based on Article 82, a claim is being put forward against TikTok because of collecting sensitive data of children and selling them to advertisers. But the size is immense, 6 billion euros. So that's very un-Dutch.
Well, thank you, Philip. That's very, very interesting. I want to make a point on the anonymity in a second, but that TikTok case is one that we're seeing replicated, all over the world. There's already been a case in the US. The previous children's commissioner in the UK is also bringing one on behalf of various representative groups and so on. They just seem unafraid to be a ripe target for Article 82 claims because of the combination of the unholy combination, perhaps, or the holy combination of children's data and sensitive data is a very difficult one, plus exploitation of children is the way it's framed by the claimants. Not saying I agree with that, but that is sadly the way that those claims are being framed, and they will, I'm afraid, run and run. The anonymity decision is very interesting because it's something we talk about with clients a lot. And Marco might mention it. We're soon to come to Marco for his take on Italy. But clients often ask us, is there any way we can have, at least not quite our name removed from an ICO decision, but can we have our very confidential processes and technology that we use that might have been being explored in the investigation? Can we at least have that redacted so our competitors don't know what we're doing and so on? And I have to say, regulators do often listen to that, but not always. So you do need to be aware when you are subject to these investigations and potential fines that your dirty laundry is potentially going to be exposed to the world, and there is not much you can do about it. That said, it sounds like in Holland you can, although we don't.
Well, yeah, that was because if you look at the court case, I think that the arguments that were placed by the DPA are not very strong. They are saying that the public interest was served by it, but the public interest is not served by the naming and shaming of the company. It is served by the content of the decision and how it came about, but not necessarily the name. So I think that the company has a point.
I can see that, Philip. But although sometimes, of course, the public interest must have the name. If there's a breach in relation to I don't know, an aviation company, as we have seen, you need to know, good Lord, I am part of that. Shall I contact the company? Just one final point before we go on to. I'm just going to talk about the Luxembourg decision before we move on to Marco. But Philip, do you think that in the next 3 or 4 years we will see? You talk about the gloves coming off, but will the regulator in Holland actually start landing punches? Because Holland is a key place for international headquarters, always has been and has grown a little bit since Brexit. And much like Ireland, will they come under pressure from other regulators? And Linda will touch on this, no doubt, in relation to the WhatsApp fine in a few minutes. But do you think the Netherlands will start coming under pressure, if they are the lead regulator for various entities, to start fining at a high level? And will that then cause a contradiction with the open and friendly Dutch corporate model? Come and list here, come and have your headquarters here for various reasons.
Yeah, I think that I'm not sure if you could call it that the DPA is going to be pressure under certain pressure, but yes, it's fair to assume that not long before now we will get fines where they will, because they have their own guidance about how to calculate the fine. And in the case of CPNA, it was clearly linked to the size of the company. So if you are talking about a multinational company, they will look at the same things that other countries are looking at, Germany or France, I guess all the countries, like what is your responsiveness, what is your level of cooperation, etc., and what is the seriousness of the breach. So they will, in the end, it's likely to assume that the same types of fines will be imposed in the Netherlands for those kinds of companies.
Cool. Well, thank you, Philip. That was very interesting. And obviously, Linda will touch on that issue a little bit in the WhatsApp thing, just how Ireland have dealt with, having to fine these large multinationals. Just before I move on to Marco, I'm just struck by Philip's anonymity case. There's an interesting one in Luxembourg that you're all aware of, which was slightly the other way around. We all know the problem child, Amazon. No criticism of Amazon, but obviously they have been fined, 750 odd million euros by 750 million, just so that everyone is clear, euros by the Luxembourg Data Protection Authority, the CNPD. That is a record-breaking fine. That's the top fine that's ever been given. Guillaume will mention, I'm sure, the very first large fine, the Google 50 million fine, but that seems a long time ago now that we're at 750 million. But the strange thing is, although we can guess that it's something to do with marketing and excessive use of the data for contacting customers and so on, because of Luxembourg's secrecy laws, we actually don't know anything about the ratio of the decision. So unlike Holland, where we don't know the perpetrator, but at least we can see the ratio and we can see what limits there might be on use of biometric data for entry to business premises and so on. In this case, we know it's Amazon, we know it's 750 million. We just about know that Le Quadrature du Net, the French privacy activists, were involved. But apart from that, I have no learnings from this decision at all. So it's a very, very strange decision, and one that is quite fascinating. I'm just unclear how Luxembourg, no criticism of Luxembourg, obviously, no doubt are there for a reason, but it's difficult to be, seems to me, to be an effective supervisory authority if you can't reveal the reason for decisions, because as a data controller or a processor, I can't learn from those decisions. But that's just my substandard as usual comment. But I will move on to yes, the view from Italy. And the only thing we have on this slide here, Marco, is, oh good Lord, sorry. The view from Italy. So as always, Marco will be fascinating, but not giving you too much of a lead in, Marco, but welcome, Marco, from Italy.
Thanks very much, Alex, and thanks everybody. It's always good to be here at speed dating and talking about data protection. And I think the slide is pretty cool because you kind of get it It's like the matrix, the data, but you kind of don't. And that's the situation right now with inspections from the Italian Garante della Privacy. Why am I saying that? Is because in Italy too, like in the jurisdiction we've just visited, the fines have started, the inspections have started, and the gloves have started to come off. The decisions not only have concerned themselves with fines, but with many statements, declaration, and orders, which has seen a trend emerging in businesses that are subject to Garante action, as in how do I measure compliance? And what if the Garante during the inspection takes a position on something other than data protection? We know that the application of GDPR from the very beginning had the clear intent of being all-encompassing. So a law that did take care of all data processing, and therefore an inspection that took care of all that processing. And references to data are everywhere in employment law, commercial law. They are all the cases we've discussed. They have presented a number of legal issues that are not directly linked with data processing, but have come into the decision and have come into the inspection. Therefore, one question is, what value do the finding of the Data Protection Authority have other than the processing, the data protection, and the fine? So if I do choose, like H&M did in Germany, to do not challenge the fine and just pay it and comply with the order, does this mean that the whole reasoning of the Garante is to be taken for granted for the future? This is emerging as a very serious issue. Why? Because if fines are new, then cases on fines and inspection are even newer. And the position of courts is, as of now, confined to urgent matters, like the one Philip was talking about. We do not have consistent national case law on appeals against decisions. The decisions of the Italian DPA are very wordy. They're very long, and they have known to be published the very second they are taken. So, and once they're out in the net, I mean, the anonymity case or the naming and shaming is taken care of, because, you know, a screenshot is enough to shame you forever, as we very well know. So the main focus of the legal reasoning here, other than everything that's just been said, which I fully share, both the dissuasion point Alex was making, the turnover point Jessica was making. So there are a number of common questions. We know that the position of the regulators and the papers on how fines are singled out do have very general clauses. They have the headline grabbing 2 or 4% of global turnover, but other than that, the meat on the bones that was mentioned earlier is still growing, but it's not a set of rules that can be relied upon. So the question is, if I challenge on what basis, what will the court think, and the orders of the data protection authorities all over Europe do have an effect, do have a legal standing outside the, I'm not saying narrows because they're not boundaries of data protection. If the Garante takes a decision on status of employment relationship, or takes a decision on monitoring in the workplace, or takes a decision on my company system, and qualifies it under whatever legal provision you have. And I do not challenge this because I want to pay a reduced fine, because I want to find a way to amend my privacy protocols. Does this mean I'm accepting what the authorities are saying? It is more practical than it sounds. I mean, being a lawyer, I don't want to sound too practical, otherwise I spoil clients during webinars, and when they ask for advices, then I do not match this level of practicality. But it's true. I mean, if a company is fined and if a company is given orders on data protection, and those orders have parts that impact the business otherwise, do they need to appeal? And if so, does an appeal on data protection cover all other jurisdiction or issues? I guess we'll have to wait. In Italy, we still do not have consistent case laws on appeals, on guarantee decision. It is all very early stage. It is all very collaboration with the guarantor, find a way to comply, find a way to manage fines. But given the increasing nature of the fines from a quantitative side, and given what Alex was reminding, because Article 82 is there, waiting in the wings, because we do not know if it's a large company dealing with large number of data subjects, and I say your system is unfair or was unfair in this respect, then it means that the floodgates can open, and I've seen in the TikTok claim action that Philip just mentioned, it seems they already have. So that's another point to consider, and again, it takes us to courts. How will national courts and European ones maybe react to the consequences of fines and finding by authorities? No answer there, but a very cool slide to try and begin the thinking. Thanks very much.
Well, thanks, Mark. As always, that's very interesting, and I think everyone's grappling with all the issues that you talk about. The width of the competency of the authorities. We do see the ICO make comment on things that perhaps they shouldn't make comment on, and it is just very difficult to then deal with that. I can, by the way, now see these questions, but I'll come back to them later at some of the panelists. Before we head on to Linda, just in a moment, I thought it was an opportune time just to talk about international incidents and how you deal with them, because obviously a lot of the things that we're talking about now, and especially what Linda's going to talk about, have very much an international piece. Although the H&M fine was a domestic incident in Germany, the fines that Linda is going to talk about are ones that have had an impact in Ireland, in X jurisdiction, in Y jurisdiction. And from a workplace perspective, most of the breaches and the incidents that we deal with that of course give rise or have the potential to give rise to a regulatory complaint or a fine, ultimately, do tend to be international incidents. It might be a UK headquartered company that has an incident in relation to its HRIS system, but that might affect 100 employees in Ireland, 1,000 in the UK, 3 in one German state, 9 in another German state, 20 in France, and so on. I go on. And it is very important in that complex moving piece, which can have cross-border elements, to just understand what you're doing, because mistakes made early, not picking up the fact that this is an international element with potential, and when I say international, I don't just mean European and UK. I know we're focusing on that today, but you might miss a notification obligation in Australia or in Singapore or in Hong Kong, and that can have ramifications later for the fine profile. And equally, Brexit adds to the complication, because of course, we in the UK, as UK headquartered business, would want to just deal with the ICO. We can't now. We will have to deal with the ICO and potentially at least one other European regulator, potentially, depending on the setup of our establishment, multiple EU regulators, and indeed in Germany, potentially multiple German regulators, although that actually rarely happens. But so it is very important that early doors in an international incident, workplace or marketplace, you work out jurisdictional issues, work out administrative issues. Are there any jurisdictional challenges that you are going to have to work through? You're going to have to work out what kind of worldwide team we need and what the different timelines are for reporting. It is an extremely hard thing to deal with. And the number of times we've come in late in the piece to help people with incidents, this hasn't been thought about. And luckily we've recovered things, I guess, through either my own brilliance or more likely just sheer luck. These are things that if forgotten about, suddenly you're turning an incident that has some seriousness into a major thing because you forgot to do something you needed to do in Germany or France or Ireland or the UK. So we could do a session in and of itself on how to deal with an incident. And indeed, perhaps we will do an incident response speed dating later on in the year or next year. But just do be aware of that. And I think that's a nice piece to move on to Linda. And in fact, the first fine she is going to talk about, not a workplace one, but certainly one that had significant international issues within it. Thanks, Linda.
Interesting, you're talking about the kind of response times as well, Alex, because the other case that I'm going to talk about is Twitter, and their breach incident happened over the Christmas period, which certainly added to the issues that they had in terms of that fine. So interesting from an Irish perspective, when we started thinking about this topic, there actually wasn't much to talk about in terms of fines. And as I think everyone on the call will know, our regulator has been criticised in a European perspective for the speed of how they carry out investigations and also for the low levels of fines. But actually, as has gained a lot of publicity in the last week, last Thursday, they issued a large fine to WhatsApp of 225 million euro. So that is one of the largest fines issued under GDPR and the largest by far in Ireland. So it wasn't a workplace fine, but it is interesting in terms of showing, as we've been talking about, are the gloves off from regulators in terms of the levels of fines. So this was a fine for breaching their transparency obligations with regard to the provision of information and the transparency of that information, interestingly, to both users and non-users of the WhatsApp service. So that included information about processing their data between WhatsApp and other Facebook companies. And as you said earlier, the investigation did take a long time. It took over 2 years, and that is because it is a cross-border issue. So our regulator had to submit a draft decision under Article 60 of the GDPR to 8 other concerned supervisory authorities. So as well as the length of time it took for the investigation, that process also had to be gone through by our regulator. So it's interesting, and it was reported in our media, I would say maybe 6 to 8 months ago, that WhatsApp had accrued 75 million in their accounts in terms of this fine, because it had been indicated that our regulator would issue a fine of between maybe 30 to 50 million euro, and that our regulator felt that was appropriate. But actually, when it came to that Article 60 process, that level of fine was disputed by several regulatory authorities, particularly around the question of whether that level of fine was effective, proportionate, and dissuasive, as you talked about earlier. So that's quite interesting. Because the various regulators couldn't reach consensus on the actual sanction, our regulator then had to refer the matter to the European Data Protection Board. And so then they issued a binding decision, which basically said to our regulator, it's got to be higher. So they then reassessed the decision based on the European Data Protection Board decision and came up with this higher fine of 225 million euro, along with the relevant reprimands. And also, interestingly, they had suggested a 6-month time frame to comply with the remedial measures that they wanted WhatsApp to take. And that time frame was reduced to 3 months, which is quite significant difference in terms of remedial action. So as it naturally would be expected, WhatsApp have confirmed that they are going to be appealing that fine. So it is watch that space, but really interesting development in Ireland in only the last week, so hot off the press. The other fine then that I actually had initially wanted to talk about was the Twitter fine, which until last week had been our largest and was quite significant when you compare that against previous fines issued by our regulator. So that was issued in last December, and that was for 450,000 euro. Again, like with the WhatsApp fine, that also had to go through the dispute mechanism process before the European Data Protection Board. And again, in that case, our regulator was told to increase the fine. So I think this is possibly a trend we're going to keep seeing. And that was the first time that that process had been used. So that fine, the Twitter fine, might be more relevant to potential workplace issues because it did relate to their response to a data breach. So the data breach occurred in 2018, but was only notified to the regulator in 2019. Now, that sounds like it's a long delay, but actually it's not, because it happened end of 2018 and wasn't reported until January 2019. So it really was only about a week or two. So it was in respect of a programming issue that basically meant private tweets became publicly available, and that wasn't part of the private tweet terms and conditions. So in terms of the delay, the breach was picked up internally on 26th of December which is every lawyer and data protection officer's nightmare, that you'll get a call on the 26th of December saying there's been a serious data breach. But naturally, because of delays due to Christmas holidays, it didn't actually get reported to our regulator until 8th of January. So, you can really see how, from practical perspective, that could happen quite easily. And I think that crisis management that you're talking about, Alex, would be so critical in terms of making sure deadlines aren't missed. So our regulator initially wanted to impose a fine of between 135,000 and 275,000. But then following that Article 60 process and the matter going before the Data Protection Board, they had to increase it, and they increased it to 450,000 euro. Now, in that situation, some of the regulators involved wanted fines of up to 20 million euro. So quite a huge disparity between what our regulator was looking at and what other regulators felt was appropriate. Now, we do think that although it's not stated by our regulator in the decision, it is possibly likely that they took into account the difficulties of the Christmas period in terms of looking at why the delay might have happened. So in terms of general themes then in Ireland, we've only had 8 fines issued by our regulator, and the highest being the one that was issued last week to WhatsApp. But if you look, the other 7 actually only add up to 875,000 in total. So quite a big change in the last week in terms of fines. Most of the fines that our regulator has issued have actually been to public sector bodies or to government agencies. Obviously, big tech is quite large on the agenda there. So we do expect more. There's a lot of statutory investigations open at the moment. The themes we're seeing for fines are mainly around security measures, but also, say in the Twitter case, failure to comply with their breach notification obligations, and then insufficient legal basis for the types of processing that the controller is doing, and then a failure to provide information to data subjects. Those would be kind of the headline themes. Interestingly, our regulator did just hold a public stakeholder consultation process on their 5-year strategy. And one of the aims they have very clearly outlined is in their strategy for the next 5 years is working with other data protection authorities to try and get some consistency in how enforcement happens across Europe, and looking to harmonise enforcement approaches and agree the criteria for regulatory success. I think given the quite different opinions on what fines should be issued, that's going to be a hard aim to achieve in the next few years. Our regulator is constantly under pressure from other data protection authorities on the level of fines and the speed of inquiries. But clearly, just given that we are a country where we have a lot of tech companies headquartered, they're just going to be under a lot of pressure, and we expect that to continue. In terms of workplace issues, we're still seeing subject access requests being the biggest issue. There haven't been any fines for that in the workplace. Our regulator is still trying to use the amicable resolution process to deal with those. So that's a bit of good news for our participants today. Bad news in that subject access requests are still a big issue, but good news in that the regulator does try to deal with them amicably.
And very, very interesting. I will also say that it's not just pressure from other DPAs, it's also regular commentary from people like Max Schrems about the slow nature of the IDPC's process, which I think is very unfair, but of course he would say that. So, and I won't make any comment now because I'm just for time. I'm going to move straight on to Guillaume from Capstan to give the view from France. So hello.
Yes, thank you, Alex. So what we can say about France is the situation is gradually changing. The French Data Protection Authority, so the CNIL, has made, as in many countries, a lot of education, information about the GDPR requirements at the beginning. They are still doing this, of course. They are also advising the French government on GDPR issues, and they have had a lot to do this year with the vaccination and health data topics. Concerning the investigations and fines, what we can say is that probably the CNIL, so the French DPA, has relatively small resources, so they can't conduct a significant number of inspections everywhere, so they have to prioritize topics. So they usually select a small number of topics and say that this year they will investigate mainly the 3 topics, 3 or 4 or 5 different topics. They select the topics. So in 2020, in the annual report of the CNIL, they said that they have investigated almost 250 companies and imposed 11 fines for a total of 138 million. Of course, the amount of these fines seems very high, especially compared with other countries. But what we should be cautious about is that 135 million concern only two companies, Amazon and Google. So you have Amazon and Google who are sharing 135 million euros fine, and all the other companies have shared the remaining 3 million euros fine. In fact, when you take a look at all the decisions, you will not find any example of significant fines for concerning employee data and workplace matters. However, you can find a few fines where there have been several breach of the GDPR requirements by some companies, and among these violations, you can find 1 or 2 violations concerning employee data. For example, you have a case which was the decision was issued in July 2020 with a fine of 250,000 euros concerning Spartoo, so the online sale of footwear. And one of the issues, there were issues about marketing data, data security, but one of the issues that was reported is the fact that the customer service employees' telephone calls with customers were recorded on a permanent and full basis. Whereas during the investigation, the CNIL found that the supervisor of this department was only listening to 1 telephone call per week for the whole department. So the CNIL considered that it was disproportionate to record all the conversation of the employees with customer, whereas maybe it was necessary for training purposes to record the customer service employees' conversation with customers, but probably not, and certainly not on a permanent basis. So it's a very good example of the principle of proportionality which applies in many places in the GDPR. Another problem was relating to the same problem, so the recording of the employees' conversation, but concerning the information of the employees. And I think it's a good opportunity to also recall and remind that there is an obligation for the employer to inform the employees about the data that are collected and processed by the employer. And the second case is also the same kind of problem. We don't know the name of the company, at least in 2021, because in the CNIL's decision, it was they decided that the case would be anonymized after 1 year. So and all the decisions of the CNIL usually are not anonymous. So the name of the company appears on the decision, but only for a certain period of time, after which the name is deleted. So you can find the decision, but not the name of the company after this first period. In this case, the fine was much smaller, so 20,000 euros, but it was very small. It was a translating company with less than 10 employees. So in terms of proportion, the CNIL decided that it was because the company was very small and it had economic difficulties. So they thought that 20,000 euros would probably be an appropriate sanction. And here the problem was with video surveillance, because all the translators of the company were filmed on the permanent basis by the video surveillance. So they were working on in the same office, and there were 3 cameras in the office recording the employees at work. And also one thing which is important is that the company so the CNIL considered that there was a clear lack of diligence by the company to answer the questions, to respond to the injunctions sent by the French DPA. So here we see a clear trend. Cooperation diligence is really responsiveness, cooperation are really key elements in all the DPA investigations. Now, if we move on to other topics than employee data, we see a clear trend. Clear trend is that the fines are getting higher, and I think it's the same trend as in other countries, but it's really clear when you see the decisions. I reported here a few decisions. So we can see for the first one, which was an online sale of the DIY products, a fine of 500,000 euros. It was concerning marketing data with a lot of violation of the GDPR concerning retention periods, information of the customers, and also a problem with the data security. The second concerning a large French insurance company, 1,750,000 euros. Again, marketing data. Supermarkets with Carrefour in November 2020 euros. And then you have the two largest fine ever imposed by the French DPA concerning Amazon and Google, both in December 2020, and both related to the cookies, which were imposed without the customer's prior consent and without the customer's prior information. So it's, and we can see here that there is a clear willingness from the French data protection authorities to impose dissuasive sanctions, with 35 million euros imposed on Amazon, and in total more 100 million imposed on Google, two legal entities of Google, including Google Ireland. And in both cases, there was also an injunction by the French DPA to comply within a certain period of time, 3 months, to change, of course, the setup of their websites, with a daily late penalty of 100,000 euros, which is also, I think, dissuasive, even for large international groups. So clearly, in all French DPA, you can see at least 2 or 3 paragraphs making comments about responsiveness and cooperation of the company. It's clear that if you take weeks and months to answer to injunctions or letters sent by the French DPA, you are in a bad situation, and probably the fine will ultimately be much higher. To finalize, so in March 2021, the French DPA announced the program and the main topics that it would investigate in 2021. Data security is a key topic. And clearly there is a clear message which is sent to companies regarding data security. Health data, of course, because of the COVID epidemic, and all the topics around vaccination and health pass and so on. And the third one is directly in relation with the Amazon and Google cases around cookies. Of course, in addition to that, the CNIL can receive complaints, and apart from the program that they announce, if they receive complaints, and if they receive several complaints concerning the same company, they will clearly investigate the case.
Thanks, Graham. That's very interesting. And I will give just a shout out to our summit event on the 29th of September, where some of the same panel here are going to be talking about the new normal and what it means for data. And one of the sections we're obviously talking about there will be the use of health data, or more accurately, perhaps the increased use of health data since the start of the pandemic. But we will see there a real difference between the UK and France and Germany. And we've also got speakers from Mexico and the US there, where you'll see an even greater difference in how we approach things. Philip is actually doing a different session, but he will, if Holland was there, we'd also see a difference there as well. So that health data point is going to be fascinating, Graham, how that plays out for the CNIL over the next year. There have been a few questions. I can see Philip's answering one of them. I'm just going to ask one before heading on to Jessica for her last very interesting bit. Someone's asked, how do the data privacy breaches or issues generally come to the attention of regulators? Company reporting, complaints by data subjects, or proactive investigations by a regulator? Well, company reporting, obviously, you know, if you feel you have to mandatorily report a personal data breach as per Article 412, not every issue we're talking about today, you know, breach of transparency rules is not necessarily a personal security data breach under Article 412 that you have to report. But obviously there, you know, if it's a serious one, then yeah, you're in the eyes of you're in the claws of the regulator, then you need to see where it goes. But yes, complaints by data subjects are enormously common now. I mean, you know, that is what we see again and again. We just see people in employee complaints just firing off a letter to the ICO or the CNIL or the Garante because they want to complain. Or we see activists group, for whatever reason they wish, I don't know, a trade union group, just firing off a complaint to a regulator because they have a bone to pick about something else. That's sort of what Marco was touching on there about the interrelationship between data and other areas. It's really a free-for-all now. Proactive investigations by the regulator are obviously less common because regulators have you know, limited resources. But you know, I've been involved with clients with 5 dawn raids where we weren't aware that this was going to happen. And you know, one of them was definitely just done on the basis of their own gut feeling about what was happening at a company. You know, the big one that we obviously see there would be Cambridge Analytica. I mean, there may have been data complaints there of which we're not aware, but you know, that it can happen. A proactive investigation by a regulator is perfectly permissible in most jurisdictions, as I understand, but it is rarer than the others because it's more likely that you will have self-notified and something will happen or someone will have complained. And I will just, because we have 3 minutes left, pass on to Jessica for the final section and then pass over to Isadora for some, well, I hope I can, there we go. Just for this final case, Jessica, because it's quite a nice way to finish with a very interesting case here about excessive video monitoring.
Thank you, Alex. Yeah, 2 sentences ahead. In Germany, it's exactly the same. There have been complaints even before the GDPR, and as you said, Guillaume, when they do get a complaint, they are forced to react, and this does happen, just like you say, Alex. Sometimes you don't know why the company doesn't know why it happens. It could be a citizen, could be an employee, it could be somebody, whoever else wants to get back to the company who has a serious complaint. So this is same trend in Germany. Also, second point, Germany's data protection authorities, which are organized by the state, so we have 16 of them, they usually issue a press release if it's a more important case. And the practice about being anonymous or not is that the larger companies are usually mentioned by name, such as HM or Notebooks Billiger here, which I will mention in a moment. But the smaller companies are anonymous. So if it's a doctor's office or a small, whatever translator, like you just mentioned earlier. So, and maybe also regarding the amount of fines or the number of fines, easily over 100 in Germany since the GDPR has come into being applicable. Now, to Notebooks Billiger, it's very similar actually to what you just mentioned, Guillaume. It's also video surveillance ongoing for over a period of at least 2 years, no legal basis. You need to keep in mind that in Germany, legitimate interest is more difficult than in the other European countries. Germany has issued additional legislation to restrict legitimate interest. And under German law, if you just say, I install a camera to keep my product safe, here it was notebooks, so it's obviously expensive, there needs to be a concrete suspicion against the person. You cannot just go ahead and install cameras all over the place 24/7. And also it needs to be the final straw, the last means, ultimate resort. Here it would have been, the company would have been obligated, for example, to control the bags of people when they are leaving the workplace, or to have a 4-eye principle instead of just putting a camera on everybody. Maybe just one more sentence on the fine. It was 10 million and the company was outraged at the amount and they appealed, and there was a discussion about the measuring of fines, and if it is appropriate, which I mentioned earlier, turnover versus profit, and can they even afford a fine? So that's it from Notebooks Germany and Notebooks Billiger in Germany. I'm happy to hand over to Isadora or you.
I just want to say one thing before I hand over to Isadora, because I know we're at time. I always thank everyone here for coming. Love speaking with everyone. Obviously, Boris, and there's such a great level of expertise, and I hope everyone has enjoyed listening to run through. It is only a run through various jurisdictions. Someone asked a question about what do we see top themes for 2022 being. I probably agree with the Keneal's one that Guillaume listed. Obviously, things like cookies aren't so relevant for employees. But if you want a workplace only centric theme that regulators might look at, health data. How long is it going to be allowed to take temperatures to ask about vaccines? How long will that bleed along? Will we be doing that in 25, 2030? Who knows? Use of innovative tech. We are asked every week about, can I use this? Can I use this artificial intelligence, machine learning to do this? We're going to see more and more challenges to that from employees and certainly unions. And part of that, similarly, how we're talking about this again on the 29th, but how far will we push this home working and home monitoring? If you're looking at Notebook Billiger and H&M, both broadly looking at monitoring, it's clear that Germany doesn't really like monitoring. So, if you're monitoring for data loss prevention reasons, maybe, but if you're bleeding that into monitoring, so I'm monitoring Linda in her home office to check how productive she is that going to be fair? So I think that's the kind of, however, we are at time and I can see we're losing a couple of people, although thank you for everyone who came. I will hand over to Isadora, who I think has just got a few admin comments, Isadora, and thank you to everyone as well. Thank you to all speakers.
Yes, thank you. Well, for any further questions that you might have, our panelists, they will remain available by email. And we have a variety of resources and insights on data privacy on our website, so don't forget to check them out. For more information on our webinars, you can visit the webinar section of our website to find all the past recordings and download the slide decks. While you are there, take a listen to our podcast, Talking Work, in which we talk about the world of work. Finally, I would like to thank everyone for attending, and thanks also to our panelists for their insights today. So with that, this webinar will now be ending. Thank you and have a great rest of the day. Bye-bye.
Thank you. Bye-bye.
Bye. Thank you.